Okay, let's go ahead and get started as people start joining in. Welcome everyone, and thank you for joining us virtually this evening for what we hope will be an informative presentation for landlords and tenants in the city of Richmond. My name is Monica Bejarano, and I am a Rent Program Services Analyst. Rent Program Staff Attorney Palomar Sanchez will be conducting this evening's presentation. Before we get started, I would like to share some logistical information. Please note this presentation has been posted on the website at richmondrent.org/workshops for your reference. Please also note that this presentation is being recorded, and we hope to post the recording on our workshop page as well. If you have any questions on a particular topic discussed today, we ask that you type your questions into the Q&A function on the bottom of your screen, and we will address questions at the end. Without further ado, I would like to introduce Palomar Sanchez.
Thank you, Monica. All right, so thank you again, everybody, for attending. This is the rights and responsibilities for Richmond tenants and landlords during the COVID-19 pandemic. As Monica said, I'm one of the staff attorneys for the Richmond Rent Program. So let's go ahead and get started. And by the way, we will have a Q&A session at the end, and we'll discuss that at a later date, at a later moment. All right. So here's the agenda for today. We're just going to talk a little bit about the purpose of the rent ordinance, properties covered under the rent ordinance, some important information regarding enrollment, registration, and the residential rental housing fee. Then we'll discuss just cause for evictions, eviction noticing requirements. We'll move on to the maximum allowable rent and annual general adjustments. We'll briefly discuss some rent adjustment petitions. And then very briefly discuss the implied warranty of habitability and some landlord entry issues. And I surmise that a lot of people are looking at this workshop for the last two kind of points that we're going to be discussing, specifically SB 91 and the COVID-19 Tenant Relief Act, as well as the Contra Costa County Urgency Ordinance. So that is what we're going over today. So let's go ahead and get started. All right, so first of all, the purpose of the Richmond Rent Ordinance. The purpose of the Richmond Fair Rent, Just Cause for Eviction, and Homeowner Protection Ordinance, also known as the Rent Ordinance, is to promote neighborhood and community stability, healthy housing, and affordability for renters in the city of Richmond by controlling excessive rent increases and arbitrary evictions to the greatest extent allowable under California law, while ensuring landlords a fair return. All right. This is kind of an overview of which properties are covered by the rent ordinance. So as you can see, there are really three categories. First one is fully covered. That's fully covered, or also called controlled rental units. And that is where you have rent control and just cause for eviction protections applicable to that tenancy. This particular designation applies generally to most properties, and specifically it's multi-unit properties built on or before February 1, 1995. Then we go into the second category, which is partially covered units. So this means that only the just cause for eviction protections apply. Those units, or these units, are not subject to rent regulation or rent control. So some examples of this would be subsidized units, including Section 8 tenancies, properties with one dwelling unit on one parcel. You can imagine like a single family home. Also condominiums, and then also things that we call new construction, which is anything built and has a certificate of occupancy after February 1, 1995. And on the bottom, it says that too, Costa-Hawkins, which is in reference to the Costa-Hawkins Rental Housing Act, requires these units to be permitted with a certificate of occupancy, i.e. that the permits are final and the unit is fit for residential habitation. And the final category is fully exempt. This means that the unit has no rent regulation, similar to the last type of category, and there's no just cause for eviction protection. So it's similar to the property just not being in a rent controlled jurisdiction at all. Some examples of this would be where the landlord and tenant share a kitchen and or a bathroom. Also single family homes where a permitted ADU, that means accessory dwelling unit, was added and the owner and the main house is owner occupied. And then the last one is retirement homes. All right. So some of the important aspects regarding enrollment and tenancy registration. So one, this increases compliance. So submitting information about rent and housing services improves compliance with the rent ordinance by making lawful rent levels transparent to both landlord and tenant. Registration is required for each new tenancy or upon turnover of all original occupants. And that is for fully rent-controlled units only. Registration is only required for fully rent-controlled units. Second, it supports the rent adjustment petition process. Tenancy registration provides the hearing examiner with data on lawful maximum allowable rent levels for units under consideration for rent adjustments. It also provides base year rent data for rent-controlled units. Third, it bolsters outreach opportunities. In the near future, tenants and landlords will receive an annual notice of maximum allowable rent and a guide to rent control in Richmond, informing them of vital information about their rights and responsibilities. Fourth, it improves the fee study and billing accuracy. Enrollment improves the accuracy of the rent program's inventory of rental units and its annual fee study. Landlords are required to enroll rental units and update the status of rental properties. For example, if a unit is now owner occupied, or if a Section 8 tenant moves out and a rent-controlled tenant moves in. And finally, compliance is required for rent increases or evictions. An important reason for enrolling, registering tenancies, and paying the rental housing fee is that failure to substantially comply with the applicable sections of the rent ordinance may prevent the landlord from actually raising rents, like taking AGAs, and may be an affirmative defense to an eviction lawsuit. All right. So what is the residential rental housing fee? So the rent ordinance requires the city council to adopt a residential rental housing fee following a recommendation from the rent board. So here we have a breakdown of the last few years of the fees that are associated. So if you go down to the bottom, those are the first years that fees were applicable. And so you can see every year after that. And then at the top for the fiscal year 2020 to 2021, for fully covered rental units, it's $219 per unit per year and $124 per unit per year for partially covered units. Fully exempt units do not need to pay any type of additional fee. Or sorry, I meant fully exempt units. Fully exempt units don't need to pay a fee. All right. So here are the just causes for eviction. Now, just remember that residential tenants can only be evicted, again, if they're subject to this particular part of the ordinance for one of the following just causes. And then notice, if you do want to evict that tenant for that reason, has to state one of these reasons, at least one. First one, failure to pay rent after having been served a 3-day notice to pay or quit. By far, this is the number one reason to evict. And the second one is breach of lease if a tenant continues to violate the lease after being warned in writing to cease the violation. 3 is nuisance if a tenant continues to cause a nuisance after being warned in writing to cease causing the nuisance. Nuisance is kind of what we call a catch-all. It can mean various things. It can be, from the tenant throwing loud parties all the time to, potentially violence issues like tenants fighting between other tenants or something like that. There's all kinds of examples of what a nuisance may be. 4 is failure to give access. So if a tenant continues to deny a landlord lawful entry per Civil Code 1954 after receiving a written warrant to cease denying lawful entry. So first of all, in that description, it says the landlord has to have a lawful entry first. So the landlord has to be in compliance with Civil Code 1954. And then the tenant, so they had a lawful right, but then the tenant denies them nonetheless. So that could be a just cause to evict. And we'll discuss that in a little bit as well. There are some clarifications I will go over regarding entry due to the pandemic. Temporarily vacate in order to undertake substantial repairs. So this, again, is a temporary eviction in order to take substantial repairs. You have to let the tenant back in, and as it says, the asterisk, this one and the next two, there is a relocation payment required should you pursue this particular type of eviction. The next one is an owner move-in eviction, or owner relative, qualified owner relative move-in eviction. The next one is withdrawal from the rental market, otherwise known as the Ellis Act. And finally, a temporary tenancy. Temporary tenancy is a very specific just cause only applicable to single-family homes and condominiums, where the landlord previously occupied that unit as their principal place of residence and then wants to rent it out for up to 1 year and then move back in. The two previous, the owner move-in and withdrawal, are probably the most complicated because they have a lot of different types of documents, requirements, relocation fees, and then they also have things that attach to that property in the future, even after the owner move-in or withdrawal is performed. All right, so this is some of the written warning notice requirements. So these warnings, which are required by the Richmond Rent Ordinance, must be served prior to a notice of termination of tenancy if the just cause for eviction is one of these three. So specifically, breach of lease, nuisance, or failure to give access. In either of those three just causes, the written warning notice must be served prior to a notice of termination. It also must provide the tenant with a reasonable period of no less than 5 days to correct the violation prior to serving a notice to terminate the tenancy. It must state that the failure to cure may result in an eviction. It must inform the tenant of their right to request a reasonable accommodation. It shall include the contact number of the rent program. It shall include instructions for compliance. It shall include, and finally, it shall include information necessary to determine the date, time, place, witnesses present, and other circumstances. And we have actually a template notice, warning notice, available on our website should you want to look at one or use it. All right, here's some more just cause for eviction noticing rules under Richmond Rent Board Regulation 1001. First, the landlord must submit a copy of any termination of tenancy notice served on a tenant within 2 business days of serving the tenant, along with a completed proof of service. So again, they have to submit this copy to us, to the rent program, within 2 days. I'm sorry if that wasn't clear. You have to submit this copy to our agency within 2 business days of serving the tenant, along with the proof of service. So the termination of tenancy notice should be submitted online through our portal at that at that website address. Now, for properties with 5 or fewer units, the landlord may submit the notice by mail. And just so you know, because people do this sometimes, the rent program does not accept notices of termination by email. Now, failure to file the termination of tenancy notice timely, again, within the 2 business days, may be asserted by the tenant as an affirmative defense in an unlawful detainer or otherwise an eviction proceeding. So super important. All right, so the maximum allowable rent, otherwise known as the MAR. The maximum, this term is the maximum rent that can be charged for a controlled rental unit. Again, this is only applicable for controlled rental units. And another term for this in other jurisdictions, they call it the rent ceiling, but otherwise it's the same. It's just the maximum rent that can be charged for that particular unit. A rent increase cannot exceed the maximum allowable rent, but it can be less. Again, it's the ceiling, so anything below it is fine, but you just can't go above it. Even if the maximum rent is not charged, the maximum allowable rent remains the same. The landlord may choose to raise the rent to the maximum in accordance with, I should say state law, state law and the rent board's banking regulation. The MAR is equal to the base rent plus annual general adjustments plus any individual rent adjustments approved through the petition process. And the base rent is going to be either the rent that was applicable in July 21st, 2015, or whatever the initial rent was after that date. So if you started a new tenancy, let's say last year, whatever that initial rent was, that's the base rent. All right, so here is a list of all of the annual general adjustments that have been passed and approved through the rent program. Starting with 2016, we have an annual general adjustment of 3%. And by the way, the annual general adjustment, we get those numbers from the federal government, and we take, I think it's 100% of the CPI that is produced by the Bureau of Labor Statistics, and then we take that and use that as our AGA. So again, 2016, 3%, 2017 was 3.4%, 2018 it was 3.6%, 2019 is 3.5%, and in 2020 is 2.9%. A landlord must give the tenant proper notice of a rent increase per California Civil Code 827. And then part of that civil code says the landlord may increase the rent up to the maximum allowable rent with a 30-day written notice. Civil Code 827 requires at least a 30-day written notice for any increase up to 10% and requires a 90-day notice for any increase up to, above 10%. And by the way, the AGA rent increase may only be applied to tenancies in effect prior to September 1 of the previous year. So it has to be essentially, the tenancy has to have been like older than 1 year in order to start applying the AGA. All right, and so this is kind of what I was saying a little bit earlier. So what is the AGA and how is it calculated? So it's the annual allowable cost of living increase based on 100% of the consumer price index, which is the inflationary rate. When can the first AGA be taken after a new tenancy starts? So 1 full calendar year must expire after September 1 of each year. When during the year can the AGA be taken? Generally, the AGA can be taken on September 1 of each year after proper legal notice. However, the 2020 AGA has and continues to be deferred until local law allows residential rent increases, and we'll discuss that in a bit when we discuss the Contra Costa County ordinance. Can landlords bank AGA increases? Yes, the answer is yes, but there's a limit of 5% of previously deferred AGAs can be recovered each year, plus the current year's AGA. But rent increases may not be applied retroactively. So you can't go back and say, well, I missed the last 2 or 3 years of AGAs. I'm gonna, increase it, and then you owe me all of those increases for the last 2 or 3 years. That's not how it works. Rent increases always move forward. You can't go backwards. And then the limit is always going to be the current year's AGA. So let's say it's this year, 2020 is 2.9% plus 5%. So 2.9 plus 5, that's 7.9%. So that's the maximum you can increase to bank previously unapplied AGAs. If you have AGAs that are still left over after that, then you can actually apply those at the next year, the following year, okay? All right, tenant rent adjustment petitions. So here are some examples of tenant petitions that can be filed for in units that are fully rent controlled. So petition for excessive rent due to failure on behalf of the landlord to roll back the rent or for charging rent above the maximum allowable rent. So this is just a straight overcharge, right? The landlord's charging too much or they didn't roll it back. Then that means that the tenant can file a petition to adjust that. Also, there's a petition to reduce the rent due to a decrease in space, services, and or habitability. So if there are substantial habitability problems in the unit, then a tenant can potentially file a petition to adjust the rent based on those conditions. And finally, a petition to reduce the rent due to a reduction in the number of tenants allowed. So let's just say, for example, that you start with like 4 tenants, and then at some point the the fourth person moves out and the landlord says, all right, we have three, I don't want you to get that fourth person back. Well, that means that since they start out with four, then potentially that rent can be reduced by 25%, right? Because it's the percentage of how many people left. Some important petition facts. One, the landlord has a right to object to the petition, always. Two, most petitions and almost all habitability petitions will result in a hearing conducted by a hearing examiner. Similar to a judge, but not a judge. They're technically administrative law judge, but they can only rule on issues that pertain to the rent ordinance. Three, some petitions will be decided administratively if no objection is filed by the other party and the facts of the case are straightforward or not disputed. And finally, either party can appeal a hearing examiner's decision. An appeal would go to the rent board, and then you can actually appeal that rent board. When I say the rent board, I mean the actual 5-member rent board themselves. And even that decision can be appealed in court. So you would actually have to go to Superior Court to appeal their decision. All right, landlord rent adjustment petition. So here are some examples of this. The first one is the petition to increase the maximum allowable rent due to an increase of number of occupants allowed. So again, if you have someone who wants to move in their girlfriend or something like that, then you can say, well, that's fine, but I want to increase the rent a little bit. I'm going to file this petition based on an increase in occupants. And I think it's about 15% per additional occupant beyond the base occupancy level. And that asterisk, by the way, so it says a petition for an increase in the number of occupants will not be approved if it concerns additional tenants pursuant to the regulations of the Richmond Rent Board, Section 903B2. What I think that is referring to is that certain occupants you won't get a rent increase for. For example, like a child. If two people have a child, a landlord can't then say, oh, well, now there's a third person there. I want to increase the rent. You can't do that. And there's other persons that it may not apply as well. The second one is a petition to increase the maximum allowable rent due to an increase in space or services. So again, increase in space, expand the rooms or add additional something, or there's something else. And then services would be like, you added some additional service like a laundry room or something like that. And, you want to increase the rent a little bit. And then finally, a petition to increase the maximum allowable rent due to increases in net operating and maintenance costs. So this is called a maintenance of net operating income petition. I think it's probably the most common petition that I've seen from landlords. It is also very complicated. The calculation for it is complicated, and there's a lot of paperwork, and the petition itself is very long, but it's definitely doable. I have seen, some of these go through, so it's definitely a good thing to consider. And if tenants or landlords have questions about the petition process, you should definitely contact our office to discuss any questions you may have regarding the process, filling it out, or just how things work. Our counselors are ready to help. Kind of similar to the facts in the last one, just like a landlord had a right to object to tenant petitions, tenants have a right to object to landlord petitions, just the same. Yeah, and then the rest of the same. All right, so next is the implied warranty of habitability and the implied covenant of quiet enjoyment. We're diving a little bit outside of the Richmond Rent Ordinance, but this is important because it definitely ties into a lot of the aspects of the rent ordinance, as well as just like very common, issues for tenants and landlords in California. So the implied warranty of habitability is a legal theory which has been developed and defined through various court cases. The California Supreme Court has expressly held that the implied warranty of habitability exists in all residential rental agreements. And then there's a citation for that specific court case. This means that it is the landlord's duty to promise to provide tenants with safe and sanitary housing as defined in Civil Code 1941.1 and Health and Safety Code 17920.3 in exchange for collecting rent. So again, when I say, and before I move on, when I say implied, that means it does not have to be stated anywhere in the lease. It doesn't have to be discussed. It doesn't have to do anything. So long as there is a landlord-tenant relationship for a residential tenancy, then the landlord is bound by this warranty of habitability. And the same thing is true for the next one. So similarly, implied in every California residential lease, and when I say, by the way, California residential leases can be written or oral. Both are considered leases. Implied in every California residential lease is an implied covenant of quiet enjoyment, guaranteeing that tenants will be able to peacefully enjoy their homes. This is under California Civil Code 1927 and also some other case law. This quiet possession includes two requirements. First, the landlord may not take an action that substantially interferes with the tenant's lawful use of their home. Second, the landlord must take action to provide a tenant with the quiet enjoyment or quiet possession of the tenant's home if the landlord is aware that the tenant's lawful use of the property is jeopardized. So what that means is, on one hand, the covenant of quiet enjoyment prohibits the landlord from doing certain things which interferes with the tenant's use. And also it provides an affirmative obligation for the landlord to take action when the tenant tells them there's something that's, jeopardizing their tenancy. So they complain about some issue that is, within their rights and they're not causing it and something is, causing some concern. This essentially says that the landlord has to take action. Now, what that action actually is really depends on the situation. All right, Civil Code 1954 and lawful landlord entry. So landlords may only enter, and this is also, when I say landlord, it includes their agents. Landlords may only enter to make necessary or agreed upon repairs, decorations or alterations or improvements, supply necessary or agreed services, or exhibit the dwelling unit to prospective or actual purchasers, mortgagees, tenants, workers, or contractors, or to make an inspection pursuant to section 1950.5, which is the security deposit law. So again, these are the only reasons really where you have to, the landlord has to follow in order to enter into a tenant's unit. Now, there are other reasons, such as emergency or cases of abandonment, stuff like that. But, putting aside those exceptions, generally, these are the reasons that a landlord can enter. You can't enter just because you want to, a landlord cannot just say, well, I just want to inspect. No, you can't do that, right? You can't, unless it's here under the law, you actually cannot enter into the tenant's unit lawfully. So the landlord, part of this law also says that the landlord must give the tenant written notice to enter, and it must be at least 24 hours prior to the entry. The landlord does not need to provide written or verbal notice to enter in cases of emergency, such as a fire or flooding, but they do have to leave it after. The tenant cannot demand that they be there when the landlord enters. This is actually a common question, and nothing in the law says that. So tenants can't be there if they want to, but they cannot prevent the landlord from entering simply because they're not there. Entry must be during normal, quote unquote, normal business hours. The law, unfortunately, does not specify what that means, although it's kind of generally understood that it's going to be Monday through Friday, even Saturday, from about 9 a.m. to about 5 p.m., something like that, 8 to 6, 9 to 5, something like that. The landlord must state the time and date, as well as the purpose of the entry in the written notice. And in Richmond, it is just cause to evict a tenant who denies the landlord lawful entry after the tenant has been warned to cease denying lawful access and continues to do so. Now, please note, the state of California now has industry guidelines, which must be followed by housing providers, and specifically for people who want to, landlords or their agents who want to show the unit or enter the unit, they have to abide by these guidelines, and it actually says they can be a condition for entry. And so this is an important aspect because obviously right now in the pandemic, people are concerned about people coming into their unit, rightly so. You know, so there are certain precautions that the state has said, well, you know, if you want to do this, that's fine, but there are certain requirements, like everybody has to wear masks. There has to be rules, you know, posted outside the door. Anybody entering has to acknowledge that they understand these rules, and there's some other guidelines as well. And all those guidelines, again, are provided by the state of California. And if you need to look at those guidelines, they are on the state of California website, or you can contact our office and we can actually send it to you. All right. Okay. So that first part was really the kind of overview and summary of like the Richmond rent ordinance. Again, I didn't go over a lot of stuff. There's quite a lot of information just on the Richmond rent ordinance and our processes and that kind of stuff. But this part is going to be more about the new state law. Now, before I go on, I have to kind of tell you this. This part, I gotta say, I got a typo there. This part of the presentation is a broad overview of a recently passed state law and its recent extension and modification. The California legislature passed this law, and the Richmond Rent Program has no authority regarding its requirements, applicability, or enforcement. These issues may only be decided by a court of proper jurisdiction. This presentation is not intended to act as legal advice. If you require legal advice, you should contact an attorney. Answers to fact-specific or hypothetical questions, another typo, hypothetical questions will likely not be provided a response during this presentation. And finally, this presentation, including the question and answer sessions, is to provide general information only. Any question regarding fact-specific situations should be addressed at another time by contacting the Richmond Rent Program at 510-234-7368 or by sending an email to rent@ci.richmond.ca.us. All right. So the COVID-19 Tenant Relief Act. On or about January 28th, 2021, the California legislature passed SB 91, which extended the state's eviction moratorium and added several new sections to the COVID-19 Tenant Relief Act. And if anybody was familiar with the act prior to this passage, it was actually previously called the COVID-19 Tenant Relief Act of 2020. Well, one of the changes, the first changes that they did was they cut that out, the 2020 part. Now it's just the COVID-19 Tenant Relief Act, period. So the COVID-19 Tenant Relief Act, and throughout the presentation, I'll refer to it as either the Act or the CTRA, is intended to do the following. One, coordinate the state's response to COVID-19 rent-related evictions. Two, permit the courts enough time to adjust to the backlog of cases. Three, provide tenants a clear, consistent path of obtaining protection from eviction when they cannot pay rent due to a COVID-19 related issue. And four, provide landlords with basic certainty on when they can collect the rent debt owed and creates a process whereby it's easier for landlords to access the courts to seek the debts owed. Now, I will also talk briefly about some of the state rental assistance funds, but most of this is going to be regarding the COVID-19 Tenant Relief Act. All right, so what does the Act do? Right, this is a huge piece of legislation. When you print it out, I think it's about like 50 or 60 pages. So it's really, really long. And again, this is just a bare bones summation of this law. Particular questions regarding this law may be kind of difficult, but I will do my best to answer them. But you know, if you have a specific question, again, you may just want to contact the rent program during our normal business hours. So again, what does the Act do? The Act modifies and or creates the following areas to achieve its goal. It creates a notice of rights. It creates two categories of debt. It amends the notice of termination of tenancy for non-payment of rent. It creates a declaration of COVID-19 related financial distress. It amends unlawful detainer, or otherwise known as UD, and I'll use that term throughout the presentation, records. It prohibits certain evictions. It amends small claims court actions and limitations. It creates incentives and requirements for the distribution of state rental assistance funds issued by the federal government. It prohibits certain actions and creates requirements for landlords who have tenants with COVID-19 rental debt. And it amends anti-retaliation statutes and prohibits housing providers from using a tenant's COVID-19 rental debt as a negative factor for future housing. All right, so some of the definitions here, and again, these will be used throughout the presentation. So when I say covered period or this period, this is what they're talking about. So the CTRA defines a period of which it covers, the covered time period. So again, this is now the law. Before, the dates were different, but everything from this point forward is now law with the passage of SB 91. So the covered time period is the time period between March 1st, 2020 and June 30th of 2021. The CTRA then splits rental debt into two types of categories. First is the protected time period. So that's the time period between March 1, 2020 and August 31st, 2020. Then there's the transition time period, and that's a time period between September 1st of 2020 and June 30th of 2021. So previously, that period only went to January 31st, but now it goes to June 30th. And again, these three terms will be referenced throughout the presentation. All right, this is an important new aspect that landlords, anybody who's a landlord here should definitely be listening to. So on or before February 28th, 2021, that's the end of this month. Again, February 28th, landlords must provide tenants who, as of February 1, 2021, owe rent for the covered time period with a written notice in 12-point type that explains the tenant's rights under the CTRA. The notice must recite verbatim language provided in the state law. You cannot just create your own. You can't supply, some other, maybe someone else has their own. You can't do that. You have to use verbatim language. The notice is separate and distinct from the notice of termination of tenancy. So it's not the notice of termination. This is just an informational notice. A landlord must serve this notice before serving any notice of termination for non-payment of rent. And a landlord may serve this notice concurrently with any termination for non-payment of rent before February 28, 2021. Now, if you have specific questions regarding this notice or how to move forward with an unlawful detainer, you should consult with an attorney. So my point is with this one, and again, I'm talking specifically to any landlords who are listening, you have to send this notice by the end of the month. Even if you're not planning to, it's just, even if you're not planning to send any termination notice like, this month, if you ever want to do it in the future, you definitely got to send that notice. Okay. Now, this is the notice of termination of tenancy for non-payment of rent. So this is not the information notice. Again, this is the actual notice of termination for non-payment. So the following applies only to residential notices of termination of tenancy for non-payment of rent served anytime between March 1, 2020 and June 30th, 2021, otherwise known as the covered period. First, it must be a 15-day notice, excluding weekends and judicial holidays. So the huge change on one reason is because it used to be 3 days, now it's 15. And two, you can't count weekends or judicial holidays, so essentially it's a 3-week notice. The notice must contain an unsigned copy of a declaration of COVID-19 related financial distress with verbatim language provided by the state. Again, if you serve a particular notice, or excuse me, a termination notice, you must also send this declaration with it. And again, verbatim language has to be the exact same language issued by the state, or else it's unenforceable. At the very least, it must be in the same language the lease was negotiated. So if it was negotiated in English, it has to be in English. If it was negotiated in Spanish, it's got to be in Spanish. It must specify the amount owed and apportion it by month based on the day it became due. And it must contain specific verbatim language from the CTRA. So on the bottom here, you have some references to the specific civil codes, codes of civil procedure that you would look at. And by the way, on our website, we have some links to some of these documents, like the declaration and that kind of stuff. So for notices that seek rent owed during the protected period, the language comes from CCP, that's Code of Civil Procedure 1179.03, Section B4. For notices that seek rent during the transition period and were served before February 1, 2021, the language comes from CCP 1179.03 C4. Both of those are unchanged, by the way. The last iteration of this law had those already. But now there's a new section that says for notices that seek rent during the transition period and were served after February 1. So that means now, right? Any termination notices that you serve, that you want to serve from this point on, the language has to come from 1179.03 Section C5. Okay. So this is continued. So what happens if a landlord's notice does not comply with any of these requirements? Well, it's just very clear. The law says the landlord's notice is defective. So if you reach the unlawful detainer stage, the case may be dismissed, and depending on your written lease, a landlord may owe attorney's fees. So you definitely have to make sure that you're in compliance with this law should you be pursuing an eviction for non-payment of rent. And finally, the notice requirements are retroactive and apply to rent owed during the covered period. So again, you're looking at time in the past, and this law covers all that time up until March 1st of 2020. Now, what if a landlord serves a notice based on rent owed that overlaps between the protected and transition time period? Well, that means that the landlord has to serve two separate and distinct notices. And now, in fact, there actually may be three, right? Because you have one that was in the protected period and one that was in the transition period before February 1, and then one that was served after February 1. Each notice must comply with the separate rules governing the protected period and the transition period. And again, those are here at the bottom, right? So each different type of notice is in a different section of the law. The language in each applicable notice is verbatim and issued by the state and cannot be modified. And failure to use such language renders the notice void. And again, you may lose your case should your notice not be in compliance with the law. All right, so we're going to talk a little bit about the actual declaration of COVID-19 related financial distress. So how does a tenant take advantage of the protections under state law? Well, if the tenant only owes debt during the protected time period, the tenant need only return the signed declaration to the landlord prior to the expiration of the 15-day notice of termination of tenancy for the state law protection to attach. Once returned, the landlord can never, ever evict the tenant for the debt owed during the protected time period. So again, if it's the only rental debt is during the protected time period, so that would be March 1, 2020 to August 31, 2020, and then the tenant returns that declaration, then that tenant can never be evicted for that debt. The debt itself is not forgiven, right? And we'll talk about that in a second, but the eviction part of it is gone. Now, if the tenant owes debt during the transition time period, the tenant must return the signed declaration to the landlord prior to the expiration of the 15-day notice of termination of tenancy, kind of similar to the last section, right? And, right, but there's an additional requirement, and by June 30th, 2021, they must pay 25% of the total amount of rent owed during the transition period. So that means that tenants have until June 30th, 2021 to pay 25% of the total rent owed in order to avoid an eviction. It's not every month, it's just by June 30th. And again, it's the total. So as long as they pay that 25%, they have satisfied that requirement. If the tenant does these two things, the tenant can never be evicted for the rental debt owed during the transition time period. All right, returning the declaration. So how does a tenant return the declaration? Several options, right? One, through US mail. If you do that though, tenants are encouraged to ensure that they can track it and it is to the address provided in the notice. Now, tracking can be a myriad of different ways. Otherwise, tracking can also mean just documenting. It can be a proof of service. You can have certified mail. You can, take a picture of it or whatever. As long as you document it somehow, that could be helpful. In person, via email, if the notice provides for an email, through the same method the tenant delivers rent, if possible. And now tenants are encouraged to document, as I said, the sending of the declaration by any means possible. Similarly, landlords are also encouraged to document the sending of any applicable notices and declaration forms. Again, since there are such strict requirements in terms of sending these particular notices, the declaration, it's just advised, it's good practice to just document it in any way possible. All right, now what happens if the tenant does not submit the declaration? So that means that, let's just say the landlord gave a notice, gave the declaration, but then the tenant does nothing within those 15 days. Again, they have that window within the 15-day notice expiration to give you back the declaration. If they don't, that means the landlord may proceed with the filing of an unlawful detainer eviction lawsuit. Now, is there anything the tenant can do? Now, upon receiving the unlawful detainer, the tenant may attach as part of their answer the declaration. So essentially, they get 2 bites of the apple. They, can get it to send it back when they get the 15-day notice, or once they get the UD, they can attach it to what's called their answer. That's the official legal response to an unlawful detainer lawsuit. Now, once the court receives this declaration, the court must set a noticed hearing. At that hearing, the court must determine whether the failure to submit the documentation was a result of mistake, inadvertence, surprise, or excusable neglect. If the court finds one of these aforementioned bases, the court must do either of the following. If the UD seeks debt only during the protected time period, the court must dismiss the case, right? So if they, failed to send you back the declaration, but again, this is only for the protected time period. Remember, the protected time period, they didn't need to pay 25%. It's only the declaration. So then if they send it with their answer, case is over, it's done. Now, if the UD is filed before July 1st, 2021 and seeks debt during the transition time period, so again, this is prior to any time between now and July 1 of this year, and it seeks rental debt from the transition period. And again, the transition period starts September 1, 2020 and goes to June 30th. The court must dismiss the case, right? Because they have to make sure that the tenant is allowed the time to pay that 25%, right? You cannot go forward with an unlawful detainer until after July 1, right? Now, if the UD is filed after July 1, 2021 and seeks debt during the transition time period, the court must give the tenant 5 days to pay the 25% of the total rent owed. And if it's paid, then they dismiss the case. So again, it's not just a locked case if they just fail to give you either the declaration or the 25%. They essentially have another shot depending on what the court determines. And again, all of this is based on the fact that, the failure to submit the documentation was a result of mistake, inadvertence, surprise, or excusable neglect. Okay, recovering rental debt and the Richmond order grace period. So beginning August 1, 2021, landlords may pursue COVID-19 related rental debt in small claims court. There are no limits to how much can be sought in each case and how many different cases may be brought. Previously, there were limits. You know, you couldn't have more than, I think, one case per calendar year over $2,500. And there were also limits of about 5 or 10, I think it was $10,000. But now, you know, there is no limit. You can go to court and allege as much as you want, and you can file as many cases as you want. Now, what about Richmond's grace period? Now, remember, the Richmond passed an order prohibiting certain things last year. And Richmond said that the grace period began September 30th, 2020 and ended, or will end, September 30th, 2021. Basically allowed tenants basically up to a year to pay back any of the rental debt that they owed prior before a landlord can, you know, try to evict due to that debt. And so the CTRA, though, now prohibits certain extensions of locally passed legislation for the repayment of COVID-19 rental debt. The latest version of the CTRA actually prohibits extensions of repayment periods beyond August 1, 2021. Now, based on the applicable circumstances and factors, we have interpreted that this means that landlords can likely seek COVID-19 rental debt, which was incurred during the period of the Richmond order, which existed on or about March 16, 2020 to September 30th, 2020, in small claims court on or after August 1, 2021. So it's an important distinction. Previously, again, it was September 30th, but now it's August 1st. Now, what about the 25% rent payment requirement? How does that work with the grace period? Well, that is a separate and distinct requirement, as it is a requirement under the CTRA. Richmond grace period will only protect tenants from immediate small claims court action. To avail oneself of the protections of the CTRA, again, that's preventing evictions, the 25% of rent must be paid in accordance with the state law. Now, here's some important new aspects of the law to definitely understand. First of all, as I said before, small claims court actions, specifically small claims court, not superior court, shall not be brought before August 1, 2021. So you have to wait until then or after that. 2, this is a brand new section, security deposits. The law now prohibits a landlord from applying a tenant security deposit to satisfy COVID-19 rental debt. This is applicable for the duration of the tenancy during the covered period. So a landlord may not apply a security deposit to satisfy his rental debt unless the tenant agrees in writing. But this prohibition, there is no prohibition using the security deposit after the tenancy ends, so long as that usage of the deposit is in compliance with Civil Code 1950.5. So basically, during the tenant, while they're sitting there, while they're still in that unit, you cannot use their deposit to satisfy any rental debt unless they agree in writing. And then lastly, attorney's fees. It allows a court to limit the awarding of attorney's fees to the prevailing party in COVID-19 rental debt cases. So again, this is only for rental debt, not unlawful detainers, but in any court case, even if you have a provision or law that says, well, I'm entitled to attorney's fees, this says, no, nobody's going to get attorney's fees for these particular cases. Okay, another important aspect for landlords who, you know, if any landlord is listening, and I'm sure there are, definitely pay attention. Landlords, there is a rental assistance prerequisite now. Landlords must now seek rental assistance prior to attempting to recover debt. This requires a landlord seeking to recover COVID-19 rental debt to provide documentation that the landlord has made a good faith effort to investigate if governmental rental assistance is available, seek government rental assistance, or cooperate with a tenant's effort to obtain rental assistance from any governmental entity or third party. The court may reduce damages if the court determines that the landlord refused to obtain rental assistance from the state's rental assistance program, which we'll discuss in a second. And these types of actions shall not commence before July 1, 2021. And that's, I believe it's specifically in, that date is for superior court action, not small claims, because remember, that's August 1. And finally, this section does not apply to cases already pending before the court as of January 29, 2021. If it is pending, such cases shall be stayed until July 1st. So, you know, some of you may be wondering, like, you know, what type of documentation that means. Unfortunately, the law doesn't really clarify that. You know, this is all kind of, first of all, there's a lot of stuff that we don't know about the state's rental assistance, how that's going to work, who's going to get, you know, all this stuff. But all I can say is that, you know, if you are ever attempting to recover any type of rental debt, you have to prove that, and, you know, document that you made a good faith effort to at least investigate if it was available, if some type of governmental assistance is available. You know, some way document it in any way, because it may help you later. All right, late fees and reduction in services. This is a common question actually that I've had over the past almost year now, which is that, you know, can landlords charge late fees because tenants aren't paying the rent on time? Now, previously, the previous iteration of the law didn't have anything about this, but now it does. So they added the Civil Code 1942.9, and it says if the tenant has COVID-19 rental debt and has submitted a declaration of COVID-19 related financial distress, the landlord cannot charge late fees. You can't do it, even if your lease says so. Can't do it. You also cannot increase fees or charge fees for services previously provided without charge. And this next section is a really kind of relevant to the rent ordinance in Richmond, because, as I said earlier, one of the reasons that a tenant could petition is a reduction in services. But now the law says, well, a landlord who temporarily reduces or makes unavailable a service or amenity as a result of compliance with federal, state, or local public health orders or guidelines shall not be considered to have violated the lease or reduced services. So let's just say, for example, a property has, you know, an on-site gym. Landlord tells all tenants, you can't use the gym anymore, right? I have to comply with the local law, right? Public health orders and such. Well, that means that, you know, previously, you know, I've had some questions from tenants saying, you know, they did this, can I apply or petition to reduce my rent? And there wasn't really any guidance on that, but now there is, right? And they said specifically, if there's a reduction in a service or amenity, specifically as a result of compliance with federal, state, or local public health orders or guidelines, that shall not be considered a violation of the lease or a reduction in services. All right, state rental assistance. I have to preface, and the reason I have that asterisk there is to remind me that I really want to give this, I preface this section. This section about the state rental assistance is extremely long and very complicated. This is an extremely truncated summary of some of the more important aspects. How this state rental assistance actually rolls out is still to be determined. We really don't know, you know, when or how or who these funds are going to be, you know, available or filtered through. That's all through the state, and then the state has to deal with localities, they call them, depending on, you know, they have to treat them differently depending on the population size. So there's, like, you know, cities over 500,000, then there's cities between 200 and 500,000, and then there's cities less than 200,000. The whole very complicated, you know, measure. But some of the important aspects that I really want to hit home are here, which is this act now provides incentives for landlords and tenants to mutually participate in obtaining assistance. So again, this is under Health and Safety Code, a newly added section 50897.1 and all the following subsections under that. So what it says is that it offers participating landlords 80% of a tenant's rental arrears from April 1, 2020 to March 31st, 2021, so long as the landlord forgives the remaining 20%. And if the landlord accepts, they agree to release any other claims for rental debt, including claims for unlawful detainment. The funds may also be used for prospective rental payments, so that's payments in the future. And it offers, finally, or not finally, almost second to final, it offers tenants a 25% payment for landlords who refuse to participate in order to secure monthly rental payment eviction protection. So if a landlord just doesn't want to participate, the government says, okay, well, fine, then you're not going to get this 80%, but we will give the tenants their 25% so they can avoid an eviction, right? And then finally, the assistance provided, so if any money is given, it shall include a receipt of that assistance or the money that is paid for both the tenant and the landlord. So everybody gets a copy and documentation of what was paid and what was received. All right, so this is in regards to an anti-retaliation statute, specifically Civil Code 1942.5. So the act amended part of an existing anti-retaliatory statute. The law added a new section specifically in reference to COVID-19 rental debt. The new section states, it is also unlawful for a lessor to bring an action for unlawful detainer based on a cause of action other than non-payment of COVID-19 rental debt, as defined in section 1179.02 of the Code of Civil Procedure, for the purpose of retaliating against the lessee because the lessee has a COVID-19 rental debt. So essentially what this says is that, you cannot retaliate, or excuse me, a landlord cannot retaliate against someone by trying to, evict them for some other reason, simply because they owe a ton of COVID-19 rental debt. So it's a form of retaliation under state law now. Now, any lessor or agent of the lessor who violates this section shall be liable to the lessee in a civil action, specifically a retaliatory eviction lawsuit, for actual damages, punitive damages, and reasonable attorney's fees. And just so you know, too, this section, as far as the provisions regarding COVID-19 rental debt, ends on July 1st, 2021. So, this whole section about just COVID-19 rental debt, it's only applicable through July 1. Once that date happens, that part is going to be removed, and that's no longer going to be a basis for retaliation. All right. Here's some other important provisions to just know and understand. Again, this is super important for both landlords and tenants. Civil Code 1785.20.4. Housing providers may not use alleged COVID-19 rental debt as a negative factor in evaluating a housing application or as a basis for refusing to rent. Part of this is the understanding that from the legislature that, there's going to be a ton of people in California who will have rental debt and they may have to move for whatever reason. And then they may seek future housing, obviously. And, sometimes you have a reference into your last landlord, and the landlord, the new landlord may contact the old one and say, hey, what's going on with this tenant? Did they owe you anything? Any issues action? And basically, even if the previous landlord says, yeah, they owe me a ton of money, the new landlord cannot say, well, cannot waive that and use that as a negative factor in determining whether or not to rent to that tenant. This is a super important part of the law because it essentially protects future housing. Then there's Civil Code 1788.65. So which says that no person shall sell or assign any unpaid COVID-19 rental debt for the time period between March 1st, 2020 and June 30th, 2021. This specific provision ends on July 1st, 2021. And then in Civil Code 1788.66 is essentially the same, but The only difference is that it says no person shall sell or sign any unpaid COVID-19 rental debt for the time period between March 1st, 2020 and June 30th, 2021 of any person who would have qualified for rental assistance and the person is below 80% AMI, which means that they are basically low income. If they're low income, then and it says it's indefinite, so that means forever and all time you cannot sell or assign this unpaid rental debt for these low income people. All right, now we're talking about not this COVID-19 Tenant Relief Act, but now we're going to switch gears to the Contra Costa County Urgency Ordinance 2021-04. So the Contra Costa County Board of Supervisors voted to extend their ordinance on or about February 2nd, 2021. Again, this was already in place. It's just that they recently extended it. The city of Richmond did not renew the Richmond moratorium on evictions, and thus the Richmond order expired as of September 30th, 2020. Now, the city attorney's office in Richmond has indicated that the county's order will apply in the city of Richmond. The county's ordinance does the following for residential tenancy. First, it prohibits no-fault evictions. That's just where, there's no particular thing or act that the tenant committed. It's just that, the landlord wants to terminate the tenancy for one or more reasons. But there are exceptions to this, specifically for owner move-in evictions, so those are still good, for health and safety reasons, and for Ellis Act, or removal from the rental market eviction. So those are all still good, no-fault evictions. It also prohibits evictions where the tenant allows an unauthorized occupant to live in the dwelling unit if the occupant is a member of the tenant's immediate family living in the dwelling unit and the occupant moved in as a result of the COVID-19 pandemic. So I've seen this a bit, and I have counseled some landlords on this, and this was previously part of the ordinance as well in its previous iterations. Basically, housing has become, but it's become even more of a major issue. And, due to the pandemic, some people have had to give up their housing or move or whatever, and they end up living in other people's places. Now, even if that person is an unauthorized occupant, if they are a immediate family member, and unfortunately the law doesn't specify what that means, then you can't evict them for essentially breaching the lease, right? If the lease says, well, only you two people can live here, and then one of the two people moves in their sister or their dad or something like that, and it was because that person lost their job because of the pandemic or something like that, and it's actually not a basis for an eviction. All right, so continued. The ordinance also prohibits certain commercial evictions through March 31st, 2021. Now, according to the Richmond City Attorney's Office, the county's ordinance, first of all, prohibits rent increases on residential real property through June 30th, 2021. So again, no residential rent increases in the county, and this through June 30th, 2021. And this includes rent-controlled units in the city of Richmond, except for the following, and there are exceptions. Units that fall under Costa-Hawkins, units exempted, so that would be like single-family homes, condominiums, units exempted from state law rent control, rent increases where one or more scheduled rent increases occur pursuant to a written rental agreement that was entered into before March 16th, 2020. I haven't really seen what that means really in practice, so I'm kind of unclear what that actually is. Now, a final reminder, this is the Contra Costa County's order or ordinance, not the rent program. Although the rent program may assist in answering general questions regarding the county's ordinance, you may want to contact the county for more specific questions. All right, so that is it for our presentation of rights and responsibilities for Richmond tenants and landlords during the COVID-19 pandemic. And now we will switch on over to the question and answer period.
Okay, so I will start from the top of the list and go down. So if you already submitted a question, we will get to it eventually. We do have a few, so and we have about an hour. Okay,
Okay.
so the first question we have is if I own a single family home, am I also exempt from having to register the property?
Yes. Single family homes under the Richmond rent ordinance do not need to register. Um, they are exempt from that particular aspect of the ordinance. However, you do have to enroll. Enrollment is different from registration, right? Registration is really about the tenancy information. So like the tenants, how much rent, what are the services, when did they move in, that kind of stuff. Enrollment is required for basically all landlords except fully exempt ones, which is, it's just the landlord's information and who the landlord is, who the manager is, or whatever. And there is still a rental housing fee associated with single family homes as well. It's less, but there's still a fee.
Okay, thank you. The next question we have is I want to convert the detached garage of a current occupied rental unit into an ADU. The tenants are currently using the detached garage for storage. What steps should I take in order to be compliant with the Richmond Rent program?
That's a good question. That will probably take a more involved conversation. Again, as I said earlier, specific questions to your specific situation really are not going to be answered at this time. Our staff will be happy to talk to you, on the phone or email or even a Zoom call or whatever. But to go through that would take a little bit too much time. So I'm going to defer that one for whoever asked that question to contact our office by either emailing us or give us a call so that a counselor can go through the process and steps with you.
Okay. The next question we have is, do all these regulations apply to single family homes rented to a tenant and landlord does not live in the unit nor in an adjacent unit?
So I'm not sure what you mean by when you say regulations. If you're talking about the Richmond rent ordinance, as I said earlier, there are certain aspects that do apply and certain aspects that don't. For single family homes, there's no rent regulation and you don't have to register, but everything else about the rent ordinance would apply. If you're referring to the COVID-19 Tenant Relief Act and the Contra Costa or the Contra Costa County Ordinance, it doesn't matter, right? Those are just applicable throughout either the state or the county, period.
Okay. The next question we have is if the rent that is currently being charged is far less than the comparables in the area, are you able to increase the rent as long as it is below the maximum percentage per year?
Well, I guess that depends, right? I mean, if it's a rent controlled unit, to increase the rent just because it's there are prevailing higher markets around, that's not a reason. As I said earlier, there are specific petitions that we have for landlords, such as an increase in services or increased occupancy or maintenance of net operating income, those kind of things. But there's nothing in the law that says, well, other properties around here are getting more, so I should get more. That's not how it works, right? You have to have a reason under the law, specifically in the Richmond rent ordinance, in order to apply and pursue a rent increase. But that said, you may have some details that I'm not aware of. And so, if you have those kind of specific facts or questions, again, you may want to talk to a housing counselor to discuss your potential options.
Okay, so this one says, I tried to upload the tenant notice to rent program within 2 business days, but it did not work. So I sent it certified mail to the rent program address with a cover letter explaining the upload difficulty. Does that count?
Um, again, these kind of fact specific situations are difficult for me to answer. I just have to look, we would have to look at what happened. But again, if you mailed it within the 2 days, then that should be okay. But if there was some issue, then yeah, I think you would want to discuss that with a counselor to determine, whether or not you did comply. if you didn't, sometimes this happens where either people forget or they do it wrong. You can reissue the notice and then do it again. But again, if you have like a certain specific fact pattern, it's just better to talk to a counselor about, what your options may be.
Okay, next question says, does lawful landlord entry requirement for 24-hour written notice include text or email?
Good question. I think if, and this is just my opinion, if you have previously, had a lot of back and forth with the tenant, either through text or email, then it's probably okay. That said, to be completely safe, you would want to try to give a actual written notice. Sometimes people do multiple types of notice. They text them, they email them, and they send them a letter or some iteration or combination of those. What written notice means has expanded over the years due to the development of, email and text and stuff like that. But you can't say, well, even if you have the tenant's number or email address, but you never emailed them before, you can't say, oh, well, I emailed it to you, so therefore that's notice. No, I don't think that would hold up. You'd have to have an established kind of record in order to argue that.
Okay. Next question says, if I didn't increase the rent for 3 years, could I increase the rent for the last 3 years in this year?
If you didn't increase, well, I'm assuming this is a rent control property. You can, as I said earlier, you can bank previously unapplied, and again, I think you're referencing annual general adjustments, but there are limitations, right? So if you haven't done it for 3 years, that's probably going to be over the limit, right? The limit is the current year's AGA plus 5%. So that's 2.9, that's the current year, plus 5, that's 7.9%. But if you add up the past 3 years of AGAs, I think it's more than that. So you have to actually wait to get that third year on the next year's increase.
The next question says, what happens if the tenant doesn't want the landlord to enter the house because of COVID?
Great question. It's hard to answer, because on one hand, I understand that landlords, have lawful, valid reasons to enter into a tenant's unit. On the other hand, they give a notice and they say, there's a necessary repair that I got to do, or I got to show the unit to a prospective renter or buyer or something like that. That's a lawful reason. That said, though, due to the pandemic, things have obviously changed, right? I mean, people have, vulnerabilities. People, you have high risk tenants, they're elderly or sick or whatever it is. And so I understand the concern that some tenants may have when a person just wants to come into their unit. It's like, well, I don't feel comfortable. I mean, I use this example sometimes, but even if, for example, if a landlord gave a notice and said, well, I have a proper reason and here's your notice, and they show up the next day, but, they have a gun. Do you have to let that landlord in? Probably not, right? Because it's a threat potentially to your health and safety, right? And so here's the same kind of idea where someone come lawfully trying to get in could be a threat to that person's health or safety, or the other occupants in the unit's health or safety. So it's kind of difficult to answer because I don't really know the kind of specific facts and circumstances. But that's why I mentioned that guidelines, right? If you want to enter into a tenant's unit, you should definitely check out those guidelines. Again, they're on the state of California website. And there's a specific guideline for persons involved in residential real property transactions. And one of them that they specifically highlight is people want to enter to show the unit or enter the unit for other reasons. I would think that so long as you follow those guidelines and you follow the Civil Code 1954, you're probably okay. And then if they continue, the tenant continues to deny access, one, I would say try to work with them as much as possible. And then two, if it becomes that, egregious where you've done everything you can and they're just still denying you, that could be a just cause to evict, right? Because as I said earlier, one of the just causes is when a tenant denies a lawful entry from a landlord and is, warned about it. But, if that situation applies to you, you definitely want to talk to a lawyer about that, because again, there's all these complications right now just due to the pandemic. So.
Okay, next question. I read that the state will pay 80% if a landlord forgives the 20%. Do you know anything about that or how that process may work? Is there a link?
It's a great question. This is all from the state, and the state themselves have not, issued much besides this new law, right? And again, like I said, the parts about the state rental assistance are extremely long and complicated. It talks about like tax information, it talks about distribution, it talks about all kinds of stuff. Unfortunately, I just don't have any information to work with. No locality does, because the state hasn't really done it. They haven't said, all right, this is how it's going to work. The most I can direct you to is just the state's website and, how they're going to do it, and just to keep an eye on them. Even the rent program, it's not like the rent program, or it's unlikely that the rent program is going to be the ones to receive, who and how and when these funds are actually distributed is a big fat question mark, because unfortunately this law was just passed, and the administration of it is very unclear at this time. So all I can point you to is to look at the state's website and contact us for any updates that we may have.
This question is in regards to rent assistance. Can a landlord research now, or we cannot research rental assistance until after July 1st?
Oh, no, I would definitely try to research before July 1st. In fact, kind of similar to the last question, it's like, when, how do you do it? Well, where's the information? Well, it's hard, right? Because again, there's very little information that has been provided by the state besides this law. They just kind of say, all right, well, these are the funds. They talk about, $1.5 billion has been allocated. And then for these types of cities over 500,000, there's going to be block grants. And then for 200,000 to five, there's all these like really difficult, complicated, like provisions. But if you are researching, just document it, like if there's any information out there that you can get a hold of regarding these state assistance funds, yeah, try to research, try to document it, because again, it's a prerequisite. You have to prove that you at least tried to find something before you actually go after any type of rental debt.
The next question is asking, what are considered immediate family members? I'm assuming it goes to other laws that mention family members.
Yeah, if that's in reference, let me see. If that's in reference to the urgency ordinance, right? As I said, it doesn't specify. Right? There is no clarification, unfortunately, on what that means. Does that mean your cousin? Does that mean your grandma? I don't know. That's up to the courts to decide. Unfortunately, without clarification in the law, I can't tell you that. I can't say, yeah, it's this or that, because there's no answer. So that means that, if you perceive this person to not, if you're a landlord and you perceive them to not be immediate family, you can try, but ultimately it's up to the court whether or not, that person is in fact an immediate family member.
Okay, great. Uh, this next question is asking when does the urgency order end in regards to the evictions?
So as I said before, this, oh, I guess I didn't put it down, did I? Did I? Sorry. Oh, let me just take a look real quick. Yeah, I didn't put it in, but it's through June 30th. I'm pretty sure it's through June 30th. Let me just double check real quick. Give me 1 second. Yeah, it's through June 30th. Sorry
Okay.
about that.
Yeah. Thank you for looking at that.
Mhm.
Okay. So the next question, let me see. The tenant sent us a 30-day notice for the intent to vacate. What happens if they refuse to leave the property at the end of the month? Can we enforce that?
So they gave a notice to vacate.
Yeah, they gave
I'm sorry, can you go
sure.
ahead and read the question again?
The tenant sent a 30-day notice of intent to vacate. What happens if they refuse to leave the property at the end of that month? Can we enforce that?
Um, I've had this question come up a few times. I used to work these kinds of cases. Unfortunately, I don't think you can move forward on that, right? Because it's not a just cause to evict in Richmond when a tenant gives a notice to vacate and then reneges on the notice, right? So they can change their mind, right? They say, well, I'm going to move in 30 days. And then let's just say, especially right now, due to the pandemic, something happens, right? And they're like, oh, I can't do it. I changed my mind. I got to stay. Well, technically, they still have possession. And if they still have possession, that means in order to evict, you have to have a just cause. Again, if it's covered under just cause. But there is no just cause for a tenant when they give a notice and then change their mind before the end of the notice. I think the tenant could be liable for some expenses potentially that you expended based on the reliance on their information that they told you. But can they be evicted for that? I don't think so. But again, I'm not a judge. That's up to the courts to decide.
Okay. Let's see. Next question says, we have vacant rent controlled units. Can we rent them out at the max or would we have to get it approved first?
Oh, good question. Yeah, so for vacant units, under state law, you can reset the rent to market. You don't have to go through any approval process like with the rent program or anybody else. State law says there's a brand new tenancy or a qualifying tenancy or, qualifying vacancy. That's what I meant. Then you can reset the rent to market, and state law doesn't define what market is. So you don't have to approve it. It's just that in rent control jurisdictions, once that initial rent is chosen, then that's the base rent for all future rent increases, right? So all I can say is just choose carefully, because essentially that becomes the basis for all the future rent increases for that tenancy.
Next question is, can I be evicted if the property is being sold? I live in a separate in-law unit, where the main unit is not currently occupied.
Okay. Unlikely. If your unit is, again, it depends a little bit on the facts, but excuse me, if the unit is subject to just cause, which it sounds like it may be, then, excuse me, none of the just causes are for sale of the property. There's no prohibition on the landlord selling the property. That's fine, but they would essentially have to, sell it with you in it. But they cannot evict simply because they want to sell it. Now that's only true again for fully controlled or partially controlled units. If it's fully exempt, then they can evict for any reason or no reason at all because there's no just cause required, right?
Okay, next question is, not sure if I understand that question. Sorry, we have a lot of questions, so I'm just trying to make sure I understand these.
It's okay.
Okay, this question is asking, you mentioned that rent can't be increased. What happens to the 2.9% AGA for the 2020 year?
Great question. You know, the Richmond rent ordinance is going to have to talk about that and, you know, how we're going to deal with that in the future after June 30th. You know, all I can say is right now you just can't do it. But you know, I really can't answer that question because that's a little bit beyond my pay grade, right? That'll be up to the board themselves or, you know, senior staff. But, you know, we should have a plan for that at some point, but, you know, even if we did, it doesn't matter until after June 30th anyway now. So, but, you know, rest assured that at some point we will have some information about that particular question.
Thank you. Looks like someone just dropped a note, some information to pass on. This says the California Apartment Association also has a good amount of information regarding SB 91 that is available on their website if anyone else is interested.
Great.
The next question we have, is there a rental? Oh, I'll hold.
Okay, go ahead. I'm sorry.
No, that's fine. Is there a rental assistance grant for my tenant? They applied for a $5,000 grant and we were told that Richmond ran out of funds.
I'm not sure which fund you're talking about. There were several, but I don't know. You know, if they applied and they said there were no more funds, then probably were no more funds. But again, those were likely the local funds. You know, there was like Shelter Inc., and then there was the Richmond Rapid Response Fund, and maybe one or two others. But I think the more kind of immediate funding will probably be from the state. But again, if and when that actually rolls out is very unclear.
Great, thank you. Okay, the next question is it beneficial, to file a 15-day notice now when no action can be taken until July 1st?
I mean, you know, to preserve your right, it may be, right? And first of all, you should probably talk to an attorney about this, right? I can't give you legal advice, but, you know, the law does say that in order to pursue an eviction, you have to give a 15-day notice for rent that is owed. And you have to comply with all the other requirements that we, you know, kind of previously went over. I think just personally, I mean, yeah, if you want to preserve that right, you probably should. You can, you know, and tell them that, you know, I'm just kind of following the law. Here's this notice, that kind of thing. And, you know, just remember that your notice has to have a declaration. You have to send the informational notice, and you have to wait to see if they pay that 25% by June 30th. But, you know, just to wait until the very end seems a bit, you know, just the timing seems wrong, because if you wait and then you have to go back and like look at the law and then see, okay, well, which notice and for which month, you might as well just give it, you know, if there's something owed.
Great. Next question is, how do you send a declaration and a 15-day notice? Or what is the process for that?
So these are outlined by state law. You know, how you would normally send a notice of termination of tenancy would be usually through some type of mail, and you can put it on their door. It's called nailing it and mailing it. You can send it in any way really that you can, as long as it complies with the law and that you can document it, it's probably okay. But again, there are specific laws regarding issuances of termination notices. But again, if you send it either by mail and you post a physical copy, you're probably okay. If you email it and send it in the mail, or what, there's all kinds of ways you can do it, I think, theoretically. But I would just check the law to make sure that you're in compliance, or speak to an attorney.
Great. This is another question. Can you confirm if rent freeze is no longer applicable and if I'm able to increase the rent at this time? Also, can the rent board help me calculate the bank increases or the banking via Zoom or in person?
The answer to your second question is very easy. Yes, absolutely, we can help. We can go over your calculations with you, Zoom, phone call, email, whatever you need. In terms of the freezing, yes, there is, as you can see here, there is a prohibition on rent increases for residential real property through June 30th of 2021. And this includes rent-controlled units in the city of Richmond, and that's according to the Richmond City Attorney's Office. So there is a freeze until after June 30th.
Okay, next question. Can I take my rental unit off the rental market because I need to move back in?
When you say off, that's kind of conflating two separate laws. And again, I don't know if that means eviction, or if you're trying to evict a tenant because you want to move in, or you want to just remove the remove the unit from the rental market. An Ellis Act eviction is extremely complicated and very expensive. So it actually would, if you just want to move in, it doesn't make sense to do it that way, because you can just do an owner move-in eviction and the relocation fees are far less. But again, it kind of depends on the unit and how you want to do it, and a lot of other facts and circumstances. So I think for that particular question, you should definitely follow the rent program to discuss your some potential options. Although just remember that we can't give you legal advice, but we can kind of generally tell you like some of your potential options.
Okay. That was the last question we have right now.
Okay. Okay. So we can give it, another 15 minutes or so to see if anybody has any further questions.
Sure.
Actually, I'm going to step away just for 1 second, just go use the restroom real quick. I'll be right back.
No problem. And for those who are still attending, I'm going to drop the link to our workshops page where this webinar is recorded and where the presentation is available. So feel free to visit the link that I dropped into the chat box. You may need to copy and paste it into your URL in order to access the information.
Okay.
Okay, so we did get one more question in our Q&A box. The question is asking, is a duplex built before 1995 under rent control? Each dwelling flat has its own address and separate entrance.
Most likely, yes. Duplexes like that are, it's not a single family home, which would carry a partial exemption. But if it's a duplex, it's very likely rent control.
Okay. And just to remind everybody, if you have a question, make sure to use the Q&A function on the bottom of your screen, not the chat box on the bottom. Okay. You can give it a couple more minutes and see if any questions pop up. Okay, we did get one more question, and I can answer this one. The question is, will there be a video copy of this webinar? And the answer is yes. You can visit our workshops page. I dropped the link in the chat box on the bottom of your screen. This webinar will be recorded and linked there within 1 to 2 business days. So I would check next week for the webinar link.
Yeah, and we will have an updated fact sheet as well as some updated links to some of the documents that were referred to under the CTRA on our website probably next week.
Okay, I think that was our last question. Oh, got one more.
Okay.
Okay, so the question we received, if we don't collect the 2.9% AJA for this year, can we collect it next year? I know you answered this already.
Right. Yeah, so that would be, kind of considered banking of AGAs. Obviously, some of the rules, I don't know how to say it, but we may have to discuss some of the regulations regarding banking and how that works given the pandemic and how it, prevented landlords from being able to apply the AGA. I don't know, but generally speaking, yeah, you can bank previously unapplied AGAs, but like I said, there's a bit of a limitation. It cannot be more, even if you add up all the percentages, it can't be more than the current AGA, which is 2.9% plus 5%. So it can't be more than 7.9%.
Okay. Okay, so no questions at the moment.
All right, you can give it a few more minutes, and if we have no more in about 3 minutes, then we can just end it.
Okay.
Looks like there's one.
I do see one more. This one is asking, last month we delivered a 15-day notice to the tenant along with COVID forms. However, the forms would not upload to the Richmond website. So we sent an email to Richmond about the notices within 2 days. Are we in violation for the 2-day rule, or can we mail the docs to Richmond retroactively?
The declaration is not required under Richmond law. Remember, that's just to ensure that should you proceed with an unlawful detainer based on non-payment of rent, that the tenant doesn't bring that up as an affirmative defense. You know, our ordinance only talks about the notices of termination. It doesn't talk about the declaration or anything like that. So, you know, again, I think what the question said was that it couldn't upload the declaration itself.
It's actually
Right?
asking about the 15-day notice that they served to the tenant.
Oh, I'm sorry, I misheard that. Can you repeat that then?
Sure. Last month, we delivered a 15-day notice to the tenant along with COVID forms. However, the forms would not upload to the Richmond website. So we sent an email to the Richmond Rent Program about the notices within 2 days. Are we in violation of the 2-day rule? Can we mail the documents to Richmond retroactively?
I see. I don't think you can mail things retroactively. You know, again, this is kind of similar to a question we had earlier, which was, you know, very fact specific. You know, I don't know much about you know, I'm just a staff attorney. I don't know much about the uploading of notices and how that works. So all I can say is, if you have, you know, it sounds like you have a pretty fact specific situation. I think you should definitely talk to a counselor. The counselors are well versed in the processes required and can provide, you know, good advice and options for you, depending on the situation. So I just highly encourage you to follow up with our staff at some point next week.
Okay, thank you. Okay. No questions at the time.
Okay, we can give about 2 minutes.
Okay. I think that's it.
Okay. Well, thank you everybody for joining us. I hope you found this presentation to be useful and helpful. As I said before, if you have like more specific or particular questions, definitely feel free to contact our office. You know, we're definitely open to assisting the public during our normal business hours by phone, email, Zoom, whatever you need. So please feel free to contact us with any questions you may have. Thank you again.
Thank you, everyone.
Take care, everybody.